Major bank sued for approximately $8,781. I talked to the person that won this great case and said, I didn't do an affidavit. I go, what? He said, yeah, I just loaded up my answer. And you can see it was successful for him. Not only did he win, he got the whole debt eliminated, and he was a real so-and-so doing it, and we love it. Once those aren't answered, your case is kind of over. They're going to kick and scream, but at a very minimum, you're going to settle the case because they do not want to be in front of the judge or their client saying why they didn't answer the request to omit. Because if you're not collectible, they'll fold up their tent and go home. Within just 3 days of filing an aggressive defense strategy, the bank's attorney called to negotiate. The bank suing you, the member says, often no longer owns the debt. They're just the servicer collecting for someone else. Where have you heard that before? Hey, Brian Parker here with another exciting video. I always say that, but they are exciting to me. I work all day, not all day, but a long time on them. And then when they come together, I'm like, where did that come from? But you do the work, you get the success. And that's my advice to you today with a member coming forward with a great victory in a creditor lawsuit. When you get a creditor lawsuit eliminated for the whole thing, meaning it's all gone with prejudice, that's a huge victory. It's not that the debt buyer lawsuits are easier, but the lawyers and the owners have less skin in the game when they're buying pennies on the dollar. When you're suing in a creditor case, you need to bring everything you can just to get a decent discount. And that's why we've introduced securitization, because that gets you better settlements. So this again is from a Washington state resident. Let me advise you to please check your own state's collection agency laws. I say that because I don't practice in Washington. I'm not giving Washington advice, but this comes directly from the Washington state resident to you, showing you how he won. Not only did he win, he got the whole debt eliminated, and he was a real so-and-so doing it, and we love it. Check the collection agency laws, Washington's consumer protection statutes, always statute of frauds, and rules on answering and delivering the lawsuit and discovery. This may be the first chance I can say, hey, check out my last video I did, which received a lot of positive response. The TILA video, let's just put it up there. I always do this, put it up there. So let's go. So when you get a lawsuit from a creditor, in this case it was Wells Fargo, you have to first analyze the lawsuit. I've been telling you, I'm coming up now with analyze the lawsuit, look at the documents, look at the words they use, and look at the rules that they use. So you create an answer, an affirmative defenses. How you respond matters. In this case, I talked to the person that won this great case and said, I didn't do an affidavit. I go, what? He said, yeah, I just loaded up my answer. And you can see it was successful for him. I say you do the counter affidavit, but he's really good at this, you'll see. Focus on the documents or lack of proof, and your old friend, the governing law provision. Let's put that up video I've done, the governing law provision, and the contract. Is the contract they attach, does it have your John Hancock? If it doesn't, then they've got a lot of explaining to do, and they've got to bring it in under evidence rules, which they can't unless it's the real thing or they support it another way, which gets them into a lot of trouble. So you're going to see what he did. Securitization was a big part of the member's response. What are your goals? To mitigate or eliminate the damages you're being asked to pay. Discovery, he leaned on discovery. You use discovery to learn what's the other side got, how are they proving it, support your case with your beliefs. Like he did a counter claim. So when you file an action, you'll see, or if you're sued, you'll see a lot of times the plaintiff will say, upon information and belief. That means we don't have anything. But upon information and belief, meaning down the road, we're telling the court we'll be able to prove our case. So sometimes you as a counterclaim plaintiff will say that too. Discovery will support your research. You'll find out, aha, I was right. So use discovery. Also, as this member did, he overwhelmed the Wells Fargo attorney, where the attorney is like, we got to stop this. So you'll see, what I'm gonna do is I'm gonna show you what he did and intersperse, I believe that's a word, his narrative. At certain sections of the video, I'm just gonna have his narrative so you can ride along with him and how he got to this great victory. So attached to this video at Killdebt.com, you will have an answer in affirmative defenses in Word, his, chock full of good stuff, a request to produce to the creditor, request to admits. He used that to support his securitization defense, interrogatories to a creditor debt collection response checklist. You know I love my checklist because they're so powerful for you, so you can just take the checklist. Okay, how do I respond to this thing? How do I write this thing? I've got gazillions checklists in Killdebt.com, all embedded in ParkerGPT. So with a click of a mouse, you've done your whole case. So I created a step-by-step defense strategy for creditor lawsuits based on the video today. It'll be like a little very mini ebook that'll be attached to this video. So the video is based upon a member's narrative placed into ParkerGPT. All the documents were put into the platform, and that is how I created the step-by-step defense strategy for you. So that's what Killdebt.com and ParkerGPT does. I used it today to create this great video and script and the attached, let's call it what it is again, a step-by-step defense strategy for creditor lawsuits. I hope you get to use it. So this is what we're gonna do today. Shazam, it's a member's case study summary. The situation, a major bank sued for approximately $8,781. Member, by the way, was permanently disabled and relying on SSDI. Why do I bring that to your attention, or why did they bring this to Wells Fargo's attention? Because if you're not collectible, they'll fold up their tent and go home. And he made it quite clear to Wells Fargo, hey, unfortunately, I'm disabled. This is all I rely upon is SSDI. So they did the right thing, and no, they didn't. They sued him. So now he's, and this guy is really good. And you can be just as good by following his approach. But SSDI is a way to get out of lawsuits, because the long and the short of it is they're not coming after you if you don't have any money. And it's just, you can't get blood from a stone, if you will. So that at the minimum is going to make the case go away. But they gave him a hard time, whatever reason. So he gave them a hard time, as you will see. He filed, again, the defense strategy. He filed a detailed answer with 12 affirmative defenses. I'll show you. He filed aggressive counterclaims, 7 counts, filed requests for admission, 7 requests targeting ownership and documentation, filed requests for produce, compiled over 500 pages of SEC documents on securitization. By the way, we on our Killdebt.com website have the access to that. We have a securitization search. You can go in and do the voodoo that this member did. You can do the voodoo that you do through securitization. So the outcome was the opposing counsel called within days, and I will show you exactly what else they did and how I'll show you the member narrative. Here it is. I'll give you the first little snippet from him. This is the member talking about the other attorney. The more he could tell, I was not gonna get scared, and that I was actually much more knowledgeable than he thought. So that's kind of cool. And now we're gonna show you those narratives as we go along. So introduction. The power of knowledge. The guide and this video is based upon a real case where a member of our YouTube community faced a lawsuit for approximately $8,871. Within just 3 days of filing an aggressive defense strategy, the bank's attorney called to negotiate. The bank suing you, the member says, often no longer owns the debt. They're just the servicer collecting for someone else. Where have you heard that before? This creates a standing issue and potential violations of consumer protection laws. So the member wants you to remember to understand the securitization defense. Shazam. What is securitization? Major banks like Wells Fargo typically don't hold on to credit card receivables. They don't. The bank sells all the rights, title, and interest in credit card receivables, like Wells Fargo Card Funding LLC, typically in a true sale without recourse. That subsidiary pools and bundles the receivables and sells them to an asset-backed trust. The trust issues certificates that are sold to investors. The original bank remains as a servicer, collecting payments on behalf of the trust, but no longer owns the debt. That's why when you look at the lawsuit, you'll see the word account, not debt. Because if they had the debt, they just tell you they have the debt. For some reason, it just says account. Well, that's the reason. So why this matters. When a bank files a lawsuit claiming you owe money, but they've already sold that debt to a trust, they may lack standing to sue. I see it as, at a minimum, there's at least 2 owners of the debt, and 1 plaintiff against you is not enough to say that they have a right to sue you on the debt and have you pay for that debt, because there's still an owner outstanding. And by the way, most states understand this. So if you still can be subject to claims from another owner, then that case isn't over and you can't be sued by just half a plaintiff, if you will, because both plaintiffs have to come in for that lawsuit to be perfect. So at a minimum, you've got to find and grab a hold of their pooling and servicing agreement, because that will say whether Wells Fargo, in this case, or any creditor as a servicer for the trust, has a right to do that. They don't want those. That's just like the forward flow agreement in my debt collection, debt buyer cases. They don't want to give that up to you, and they don't want to give you the servicing agreement. So that will cause them to fold their tent and go home, as happened here. But I think the power of this gentleman's personality is what made them go away and give him what he wanted. So let's take a look. So if you go to Killdebt.com, you'll find, through the securitization search is up there for you, Killdebt.com, it'll show you where to go to grab your 10K, etc. documents. So a pro tip, as this member did, print every SEC documents and organize them in a binder and reference them in your discovery request. In other words, if you're doing a request to admit, go, is this true? Is this false? Do you have this? Because it's one thing, and you'll hear this often, you'll go, hey, debt collector attorney, this is in a trust. They go, no, it isn't. We didn't do that. Of the millions they do, just so happens you have the one that they didn't do. But when you send a request to admit, that's a legal consequence if they don't admit where they're supposed to admit or don't deny. There's legal consequences there. So this also shows you, as he says, that you've done your homework, and it signals to the opposing counsel that you're not an easy target. This guy wasn't. So he analyzed the complaint. Here's what we do, Shazam. Look at the generic credit card agreement. In this case, that was the case. No defendant's name or signature, no account number, no effective date, no reference to any specific obligor. The obligor is you, the obligee is them. And if they don't have your name on something, they can't say, hey, he breached these terms and conditions, where your name or signature, or even in this case, the account number is not on the document they say supports their case. They got nothing. So you analyze the documents, you analyze what they say, then you crush them. So a generic unsigned agreement cannot prove you agree to the specific terms they're trying to enforce. And no signature, then it's harder to hold you to the case and contract. It's all about the burden of proof. So before they sue you, they make all sorts of allegations, and you kind of know, well, it did take out that debt. But when they sue you, they put a 90-pound cement bag on their shoulders now, see me leaning over, that they've got to get rid of to get a judgment against you. Meaning, they now have a greater burden to prove you owe this debt. And that burden of proof cannot be ignored. And you just poke holes in their burden of proof. Remember, if there's 4 elements to a claim and you knock one out, they have to prove 4 of 4, you knock one out, case goes away. So that's a heavy burden. And you just gotta hope that the judge isn't lazy in that regard. So also, the video I just did on TILA, the TILA video, let's put it up there. Everybody loved that video. You know, I made that video, it's an hour long, and I thought, oh my God, this is boring. And yet, it's getting incredible response. I have no clue what, I always say, hey, it's an exciting video. I don't know if it's good or bad. I just keep pumping out the education. Hopefully it's okay for you. So you also look at governing law issues. Many credit card agreements specify the law of a particular state. In this case, it's South Dakota. Governs the agreement. This can create conflicts with your state's consumer protection laws or the law of your state. So before you make a noise about this, by the way, here's my governing law video you should go check out. But before you make a noise about the governing law, go check out the governing law. Maybe the statute of limitations better in South Dakota than it is in this case, it's Washington. Or maybe there's other protections that they have that's better or worse. If it's worse, don't talk about it. They certainly haven't. They've sued you in the wrong state, even though their own contract, which they're claiming you breached, says it's supposed to be in South Dakota. So anyway, your answer in affirmative defenses, of course, you know I love my front loading. Shazam, you open with a preliminary statement. Cite the definition of debt collector under 1692A6 to argue that when a bank collects on a debt owned by another, or in this case, the trust, the Wells Fargo Funding LLC, they become a debt collector. What's the definition of a debt collector? Collecting for a third party. You as a third party collecting for somebody else. So you respond to each allegation. Remember, this gentleman did not do a counter affidavit. Instead, he loaded up his denials with his proof as to why, and his factual proof as to why the other side does not have a right to sue him. Here's his key affirmative defenses. Shazam, failure to state a claim. The complaint fails to state a claim because the attached exhibits don't support the allegations. Remember, bad contract, unsigned, there's really no proof, and there's a missing account number. So, and if you're suing someone for a breach of contract, have the right contract. Lack of standing. Plaintiff's not a real party in interest. That's what lack of standing means. You really don't have an interest in this case, or it's partial, so you have no right to sue the person until you have a full interest because it was sold to a trust. Failure to prove elements. Plaintiff cannot prove a valid contract, a breach, or damages if one of those elements of the, let's say, 4 elements of breach of contract. If they miss one, they miss it all, but you won't miss them. Payment according to satisfaction, that the debt's been satisfied by the sale of receivables. That's pretty good. Unclean hands. You can't sue someone with legal dirt under your fingernails. You got to be a member of the Clean Hands Club, and they are not being honest when they say they own the debt when they sue you on an account. So in this case, Washington, he claimed plaintiff may not be licensed as a collection agency in their state. In Michigan, that's not a big deal if you're not a member, but in other states, it's serious if you're not if you don't have your license in that state. Let me show you his first part of his narrative, Shazam. After I filed my answer and counterclaims and the initial discovery, opposing counsel called me and we talked for quite some time. He was actually very nice and professional. That's rare. First off, he wanted an extension of 30 days to answer the discovery and my counterclaims. You try to remain courteous and you give everybody something because you may need something from them. I agreed to an additional 10 days on the counterclaims and gave him 30 days to respond to the discovery he sent. So, member also sent counterclaims. The specific statutes will vary. Research your state's consumer protection laws, collection agency licensing requirements, and applicable provision. But as the member says, filing counterclaims transforms you from a defendant to a plaintiff. It also makes them, now they're on their heels. You're the one punching. This puts the bank on the defensive and increases the stakes significantly. If they go forward, now their client may be on the hook, and no debt collector wants to upset their client. They don't want to lose that client. So count 1, he used FDCPA violations, 2, State Collection Act violations, consumer protection violations, statute of frauds violations. He went all off. Any abusive process, number 6. So I'll give you a quick narrative, what he said as we move along. One of their claims is kind of weird. The money lent claim, that was part of their lawsuit. Let me put the lawsuit up there. I neglected that. Here's 3 pages. Shazam, that's the lawsuit against him that he defended with his answer and affirmative defenses and his counterclaim. And there is a claim for money lent very early on. I'm not going to editorialize about that because it's a Washington State case, but this guy did his research and he said in his narrative, one of their claims is kind of weird, the money lent claim. Never seen that one before. Nonetheless, the more he talked, the more he could tell I was not going to get scared, and I was actually more knowledgeable than he thought. You're probably, with a little work, going to be, let's just say it this way, smarter than the plaintiff attorney. Why? Because they got thousands of these cases and they don't respect you or you being educated. You'll see that is prevailing through his narrative, that he wasn't getting respect. So you got to batter them over the head. Once a debt collector attorney realizes you got your stuff together, you got a greater chance of settling, because they do not want to be going back to the office saying, I lost to a pro se defendant. It's just a human narrative, if you will. So here's some discovery he wrote. Shazam, request for admissions. Force the opposing party to admit or deny specific facts under oath. Strategically crafted RFAs, woohoo, can help trap the bank into admissions that undermine their case or result in deemed admissions if they fail to respond properly. I can't tell you how many times I hear from members that want me to do a video on their case, and I'll do as many as I can, that say, I sent them discovery and they ignored it. It happens constantly. And if you ignore a request to admit, whether it's Wells Fargo or you, it automatically is held against you. So whatever you ask for them to admit, most states' court rules say if you don't answer in 28 days or 30, depending on what the state is, it's automatically deemed, that's the word, admissions. So load up your request to admit, believing that they're not going to answer in 28 days, and put that on your calendar on Killdebt.com. We've got a calendar you can use just for your case in your briefcase. And you'll be so surprised. Once those aren't answered, your case is kind of over. They're going to kick and scream, but at a very minimum, you're going to settle the case because they do not want to be in front of the judge or their client saying why they didn't answer the request to admit. Why don't they answer? Because A, lack of respect for you, that you know what you're doing. And number two, they are overwhelmed. There are so many cases now, whether you consider it's because of AI or just because let me put this, the economy is going to a place where there's a lot more debt. I can tell you that from my experience. And they are overwhelmed. Law firms are a business. They want to hire as few employees as possible. So I know from a fact a lot of these guys are overwhelmed. They don't have a calendar like you can get on Killdebt.com to register how many days they have left to file a response, obviously. So anyway, here's the powerful request for admission. Securitization admission. Admit that the receivables associated with the account was sold or transformed to blank card funding LLC or related trust in a true sale without recourse. Ownership admission. Admit the plaintiff does not own. Generic agreement admission. Admit that Exhibit 1 to the complaint is a generic credit card, which it always is. So if they admit something like that, they're admitting that it's not yours. Case over, one of the elements is missing. And a lot of states say there is no breach of contract claim unless you attach the contract. In Michigan, they're sometimes a little too debt collector friendly. They go, the rule is it's MCR 2.113, I believe. And it says you must attach the contract or say in your lawsuit, the contract's in the possession of the defendant. It's an out. It just favors the defendant. That's a very rare part of a state statute. That's just a friendly state to a debt collector in that regard. And then it's with that great out, I still see major debt collectors coming to Michigan and not attaching the complaint and not saying that out, that get out of jail, if you will, card. So look for that. If you have no contract and you knock out the contract, being yours, case is over. A license admission. Admit that the plaintiff is not licensed, if that's important in your state. Admit that pursuant to the servicing agreement, if plaintiff collects any amounts on the receivables, plaintiff is required to deposit such amounts into a collection account of the bank name, issuer trust. Meaning a servicer, when Wells Fargo owns the debt, then they stick it in a pool and sell it. They are now a servicer. When a payment comes in, you keep sending it to Wells Fargo, they send the whole amount minus a servicing fee. If you can get them to admit that, which is the truth, then they just admitted that they have no right to any amount that you give them other than the servicing fee. Gee, maybe they don't own it. Anyway, here's what the narrative of the defendant is. I say defendant because I'm not going to reveal the person's name. Let's put it up there, Shazam. He tried to get me to settle for 40%. This is the other attorney. He tried to tell me that my counterclaims were frivolous and he had claims like this dismissed all the time. I informed him, I doubt he has ever seen claims that were pled with the details of my claims. Plus I already had the SEC documents, which I put in a nice binder as they were over 500 pages. And he sent the 500 pages with his discovery request. That means the attorney's got to sit there with all this discovery to answer the request to produce, to answer the request to omit. You know how much work that is? Even ChatGPT can't save you from that. That's a lot of work. So he really keyed up on them. So I also informed him that the credit card agreement that was attached to the complaint was blank. You've heard me say that 4 times. Hold on to that, okay? Meaning, I want you to use that in your cases. And nothing more than a generic version as it had no signature, no dates, and no reference to any obligor. Obligor is you, obligee is the bank. Also, the credit card statements that were attached to the complaint lacked any details such as specific dates, wow, and charges, and had no indication who made any payments on the account. Remember, watch my TILA video for what to do with things like that. I just did it. People loved it. There it is. Floating around. There it is. So he did. I attached again to the video all the documents that he's done, all the requests to produce, all discovery, his answer, his counterclaim, my checklist, the steps for discovery creditor lawsuits. But I'll just mention briefly, request for production, all documents evidencing the initial sale or transfer of the receivables to the funding LLC. So you can see what he's bearing in on. Subsequent transfer documentation, all documents evidencing any subsequent sales. Again, chain of title, the complete chain of title ownership for the receivables, origination to present. This guy watches my channel. The original agreement, good luck. Complete statements, again, TILA. Complete statements, communication records. He really went in on them. Let me give you another part of his narrative. This is what he wrote to me. Shazam. I think the kicker was that I told him, since I was allowing an additional 30 days for discovery, that he would not mind if I noticed him with a 30B6 deposition in the meantime. So 30B6 is a federal rule where so generally when you do a deposition, go, hey, I want to see your custodian of records, I want to see your assignment witness, that's what I always do. But a 30B6 is, here's what I'm curious about. I need to know the specific person in charge of this. Why that's important is you will commonly, 9 out of 10, the person that they bring when you do a deposition, I'll sit there going, this person doesn't know a freaking thing. But the attorney had brought the person as my witness, produced, because he just didn't want to get in trouble for not producing a witness, and the witness doesn't know what they're doing. So you can go after them hard 2 ways. One, I asked for this because my deposition notices detail what I want, and I go, they showed up with this guy that doesn't even work there. A lot of times, the witnesses don't even work at the place you're suing. It's like an agent or a servicing agent, and you can get them really bad. So I'm a little mean in that regard because I get mad. I start bearing in on them, how they're just totally unqualified. And when their RAs start switching to the attorney, like, help me, you just, nope, I'm asking the questions, don't look for him. They say you're qualified. Do you do this? Do you do that? No. Then how are you it gets uncomfortable. It's how my brain is made up, and I feel really bad afterwards, but I got a client to represent, and you've got your interests to represent. So secondly, a 30B6 says, I'm not asking for a specific witness. I am, but I'm not gonna name a custodian of records or an assignment witness. I say I want these specific things answered. So only a person knowledgeable about this. So there are specific cases where the person showed up after a 30B6 notice where they don't know about those things, and courts will sanction the hell out of opponents that do that, because 30B6 is invented to stop nonsense, to stop weird people showing up that don't have any knowledge. So he did a good thing again. I guess that must be a state equivalent. A 30B6 deposition is serious. So in the meantime, I did not want to waste the next 60 days waiting for them to answer discovery. He informed me he didn't think I could conduct a deposition until written discovery was completed. That's a fallacy. I hear that all the time. I'll do a notice of a deposition because I don't like discovery, to be honest with you. I just want to get them in front of me, because discovery is you file discovery, they respond with BS answers. Now you got to do a motion compel. Now they got to fight about the motion compel. Sometimes the judge is like, eh. So now we've gone 3 months. So I just go, deposition, and then attach to the depositions a ducis tecum, which means you got to bring the records with you. So that's that just means I know the rules. So he informed me he didn't think I could conduct a deposition until written discovery was completed. I then cited the court rule, I love this guy, that allowed discovery to take place in any order here in Washington State. I could tell he was looking it up as we were speaking. So now he goes into negotiation settlement. Here's my 2 videos on negotiating before and after litigation. One is beat the debt collectors. The other is how an expert approach to beating the debt collectors. So here's briefly what he expected and what happened with him. What to expect. They may try to intimidate you by saying your claims are frivolous. They may claim that they had similar claims to dismiss before. They'll likely offer a BS settlement, 40% or less. They may ask for the extension of discovery and answering counterclaims. Responds, be professional but confident, point out the specific deficiencies. Remember 2 things, well really 1, if you're just a little bit educated, you're a little bit more educated than the other side. Trust me on that. Point out the specific deficiency in their complaint. The more you do, the more respect you get. When you file an answer, that's a little bit of respect. You file a counterclaim, a little bit more respect. When you're talking with these people and you know your stuff like he said, I then cited the court rule that allowed discovery to take place in any order here. After that guy said you can't do that, the attorney said that, who does it for a living. It's beautiful. You're going to settle that case. So look for a mutual walkaway. The ideal outcome is a mutual walkaway. All of the bank's claims are dismissed for prejudice. All of your counterclaims are dismissed for prejudice. It's a negotiating tool most times. Each party bears their own costs. You pay nothing. Here's his narrative on this. Shazam. Soon he started to realize that perhaps this was not going to be the slam dunk that most of their cases were, that he said. He then asked what I wanted. Here you go. And I informed him just to be left alone. Isn't that what we all want? Especially when the game's on, which I'm going to go watch real soon. I suggested the mutual walkaway, and he said he would have to run it by the client. By the way, he already knew he can do a mutual walkaway. That's just a thing. And he would get back to me. Within 3 days, he informed me they accepted, because if he says, okay, he looks so weak. If there's a problem at all, he can go, well, this is what the client said. So he knew he had a mutual walkaway. Otherwise, he's going to have to go through 500 pages, by the way, per question. So within 3 days, he informed me that they accepted, and shortly thereafter, he provided the stipulation of dismissal with an order for me to sign. So he tells me, so there you have it. Another one bites the dust. Here's the I'm going to show you the dismissal. There it is. Just lays it right out there. The important words that you want to focus on are dismiss this case with prejudice. And that's what your big goal is. A lot of times you get dismissed without prejudice, but I never see them come back when they do that. So they're saying there's a lot of rules in Washington that follow the federal court. So CR 41A is probably how you dismiss a case with prejudice. Look at that first section. Defendant had permanent lifetime event that left him permanently unable to satisfy his obligation to plaintiff. Why'd you make him do all this work if you knew that? Anyway, he did all the work and he spanked him and he looks really good. So my hat's off to this guy. So he asked me from his notes, went through Killdebt.com, ParkerGPT. This is what you got to remember. Research securitization, find the SEC documents, understand the trust structure. ParkerGPT will do all of that for you. Burden of proof, challenge everything. Don't accept the bank's allegations at face value. Challenge the agreement. Go on offense. Counterclaims change the dynamic entirely. The bank is no longer just collecting from you. They're defending against you. Use discovery aggressively. 500 page per question, baby. Stay professional, be courteous. You want to get mad at these guys? Don't be me. Know when to settle. When you bombard the heck out of them and you hear a hint, settle that case with them. They're ready to go, all right? So Remember, this is for educational purpose only. It does not constitute legal advice. I hope you use it. I would like to provide you, just as Killdebt.com and ParkerGPT does, a skeleton that you add the muscles and the ligaments, but boy, do we give you a good skeleton, 90% there. So go check out Killdebt.com. Here's the documents that you will see attached to Killdebt.com, all in ParkerGPT, all for you. You can do this. This guy did this, and he was great, and you can be great. So be good, be great, and kick the hell out of those guys. Thanks.